I now welcome representatives of the Financial Planning Association of Australia. Thank you for appearing before the committee today. I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear, please?
Thank you, Senator. My name is Ben Martian. I'm the Head of Policy at the Financial Planning Association.
It's good to see you again.
Thank you, Senator.
My name's Brad Vermeer. I'm a Government Relations Senior Manager at the FPA.
Excellent. Thank you very much. Do you have an opening statement?
I do. Thank you, Senator.
Thank you.
Thank you, Chair and Senators, for the opportunity to appear today before the committee for this inquiry into the collapse of the Sterling Income Trust. The FPA expresses its condolences to the victims of the Sterling Income Trust collapse and sympathise with the stories of loss shared before the committee today. Australian consumers should be able to trust the financial services sector to protect their hard-earned investments and look after their financial security, particularly through their retirements. They should not be taken advantage of for the financial gain of product manufacturers, and they should have faith that regulators are ensuring that only fit for purpose and quality products come to market. The FPA is not in a position to comment on the regulator's actions in relation to this matter, but we are concerned that these types of highly complex products continue to be marketed directly to consumers, putting their retirement savings at significant risk. This is why the FPA has been calling on improved product regulation and ASIC intervention powers over many decades. The FPA supports calls for investors to be appropriately compensated for the financial loss and damages caused by any wrongdoing in relation to the Sterling products or any other financial product where the failure or loss is caused by mismanagement, fraudulent activity, or regulatory failure. For this reason, the FPA firstly believes that all financial products and services should be compelled to investigate and compensate for misconduct that may occur under their licence through the new breach reporting and consumer compensation regimes. Unfortunately, in a large part, these are currently being restricted to only financial advice licensees. Secondly, this collapse demonstrates why the recently proposed compensation scheme of last resort must be extended to cover all financial products and services, not just distributors. Products as an industry must take a collective responsibility for protecting consumers. This collapse demonstrates that there is risk of unpaid determinations and consumer detriment flowing from product collapse, that there is involvement of other financial firms or their subsidiaries funding, distributing and otherwise supporting managed investment schemes which aren't fit for consumer investment, and it is therefore an imperative for the Parliament to require the contribution to the scheme across the whole financial services value chain to support increased accountability for all participants, including MIS operators and products more broadly. The scheme should therefore be broad-based, require a fair share of contributions to be made from every financial services and products under AFCA's jurisdiction, and an independent umpire be appointed to ensure trust and fairness for contributors and consumers. The FPA acknowledges the government's recent commitment to consult on proposals to enhance the effectiveness of professional indemnity insurance in responding to the compensation claims. Having originally been recommended in 2012 by the St John Review, we have been consistent in our calls for this long overdue evaluation. Ensuring adequate insurance coverage for industry will assist significantly in protecting consumers and substantially reduce the calls on any established compensation scheme of last resort. Finally, the FPA recommends that laws around general advice provision be urgently amended to better protect consumers and make it clear that advice has not been provided, and better reflect that product information or strategy information is being provided. The general advice statement should also be amended to ensure consumers understand the risk of purchasing products without professional financial advice, and these statements should be mandatory at investment seminars like the one Sterling investors attended. Thank you, Chair, and we are happy to take any questions.
Thank you. I'll pass to you, Senator Pratt. I should just note that because of the arrangements of the hearing, we will need to conclude with these witnesses on the dot of 11:05. Okay,
Okay, I'll
So-
try and be speedy because your submission is excellent.
so
Um,
over to you, Senator Pratt.
Thank you. Your submission talks about section 912 EB of the Corporations Act to investigate reportable situations that might affect clients. If there's reasonable ground to believe the client has suffered a loss. Can you tell us about how that the gap that you explain here has affected people in the case of the Sterling Income Trust?
So this is a section of the Corporations Act which was only recently introduced as part of the enhanced breach reporting recommendations that came out of the Hayne Royal Commission. But the requirements in that section are only obligate licensees who have an advice authorization on their license to investigate misconduct or financial losses and remediate consumers.
Yeah.
So what this effectively means in the case of Sterling is that the Sterling licensees could have, if they identified any breaches of the Corporations Act, they wouldn't have been required, if it was today, they wouldn't have been required to remediate the clients for any losses that they may have suffered.
So this is an improvement or not an improvement?
Well, this is, so 912 EB, I guess, is an improvement from the fact that financial advice licensees, where they identify misconduct or loss, have to remediate clients, but it's only restricted to financial advice licensees, not financial products. So there's a gaping hole there.
Yes. And many of the people that invested in Sterling thought, oh, well, I can see reputable financial firms directing people into this investment. I'm just going to sign up without that advice because I'm going to follow their lead and not pay the overheads, if you like. Is that why do people buy into products without financial advice? Is it because they perceive that it's reputable because good advisors have suggested it?
So I think the instances of good advisors recommending these types of products is very, very minimal.
Right.
And I think
okay.
I think the problem
nub of it.
I think the problem is that, you know, these type of schemes are targeted through seminars, targeted through radio advertising. They're very complicated to understand. They've got complicated business structures behind them, but the seminars and the information that consumers are provided make them sound like all their dreams are coming true. And so there's not enough requirement for products to disclose the complexity and the risks of their products when they're in those kind of seminars.
And
this is part of.
If we force them to have adequate insurance in their own right, that would, I guess, force them to mitigate some of the risks embedded in those products in order to find insurance.
Yeah, absolutely. I can't speak for products, but I've had a lot of conversations with ASIC about professional indemnity insurance in financial advice specifically. And from the information ASIC's provided me, while they require you to attest you've got professional indemnity insurance in place, they never actually check whether or not it's fit for purpose, appropriate, meets the requirements to pay out compensation through IDR and EDR type schemes. So you've got a consumer protection mechanism that's sitting there that the regulator is required to ensure is in place, but they're not actually checking whether or not it's fit for purpose. And so my assumption would be that it's not dissimilar in the financial product space, and therefore you've got these products where investors think there's some security there because ASIC has registered the scheme. ASIC is regulating the licensees, and there's a requirement for consumer protection to be there, but there's nothing there ensuring that that's actually the case.
Indeed. In terms of your understanding why financial product providers are exempted from breach reporting in the Corporations Act, what's your understanding of that? And would breach reporting assist in giving early warnings of problems or only act as an additional cause of action after the event?
Sorry, so just to clarify, financial products are required to breach report to ASIC, and they
Yeah.
are part of the new breach reporting regime. Section 912EB requires a financial planning licensee to investigate and remediate and compensate a consumer where there's a financial loss due to misconduct or a breach. That part of it is not extended to financial products. So they will identify a breach, but if there is a loss caused by that breach of the Corporations Act, there's no requirement for them to remediate the client.
Okay, so does that regime need to change in your view for these kinds of products?
That's our recommendation to this hearing, absolutely.
I've got so many questions to ask you. I just need to try and work out how to truncate them. I'll just ask these straightforward ones first. You've recommended AFCA as an independent umpire should not also oversee the purse strings. Who should manage such a fund if that's the case?
We had a view that ASIC should some way be involved as the as having oversight of the AFCA jurisdiction and the AFCA process. There should be some oversight by ASIC to ensure that AFCA's gone through a reasonable process of trying to get compensation for the consumer where the company has gone under, that they've become party to the liquidation process. At the moment, what can happen is AFCA can make a determination, effectively write letters and ask that the compensation is paid, but there's nothing to actually force AFCA to do anything to go after the firm to ensure that the compensation and just as importantly, AFCA's own costs are paid. And so you end up with a situation where AFCA can, and I'm not suggesting AFCA would do this, but AFCA could just sit there, do nothing for 12 months, then go to themselves and say, this compensation hasn't been paid. Can you pay it? And for our members, we would expect that there would be some form of attempt to try and support the consumer and try and get that compensation for the consumer where possible.
Okay, that makes clear sense to me. You've spoken about the responsibilities in producing and marketing complex and high-risk products. Would a mandatory warning about seeking independent advice from a financial planner be sufficient, or do you think that consumers kind of will go, well, I can see other people investing in this. They had a financial planner, so I'm going to ignore that warning.
So research shows, and ASIC's done this research, but there's been other bits of research as well, that when consumers go to a seminar or attend a talk or speak to someone directly about a financial product, they actually think they're getting personal advice, and the advice has considered whether or not that product's appropriate for them. Now, from the other side, the product that's providing general advice or information is operating under a regime where they know they're not providing personal advice and there's none of the personal advice protections sitting there, but they don't make that clear and apparent to the consumer because it's not in their interest to send somebody off to a financial planner who might suggest that the client, it's not in the best interest for the client to purchase that product or invest in that product. So the research is quite...
Yeah, please go on.
So the research is quite clear that consumers don't understand when they are or aren't getting personal advice, and that advice might and often isn't in their best interest.
as you've highlighted in terms of how some of these things are directly marketed, the statements about advice, I think, are also quite clear, but there's also the reality that people weren't given the product disclosure statements until after they had signed these contracts in some instances. How do you kind of see the regulator needs to have oversight if it's simply looking at the product disclosure statement and not dealing with the reality that that these companies selling these products created a portrayal that they were giving financial advice and put the onus on their marketing material? Where do you think that leaves the regulator and their responsibilities? Because ASIC said they simply have responsibility for the product disclosure statement rather than the overall way in which consumers are pulled into this product.
I can't speak for the process that ASIC went through or the way they regulate these products. But what I would say is that there is a consistent nature to these types of products losing significant amounts of investors' hard-earned money and particularly retirement savings, that would suggest that there are metrics that ASIC could look at which would say certain types of products are more likely to fail, and we need to have closer looks at those licensees, and we need to have closer looks at those specific products. This is not the first property type investment scheme that has failed in my short history in financial services. So, it's a concern that these types of products and these types of people are able to continuously create new products, continuously take clients' money, and then continuously leave clients with nothing left.
Do you have any insight into the tools, that regulatory powers and tools that ASIC should or could have used at the time of these collapses? Don't necessarily expect you to, but I'd be interested in your perception.
I think I think reflecting on my understanding of the way ASIC operates and the conversations we've had. So I mentioned earlier in terms of professional indemnity insurance and the conversation we've had with ASIC. ASIC collects a lot of information from financial services firms and licensees. Whether or not it actually looks at any of it or considers the risks or takes proactive action based on the information they collect would be the question I would ask, given the conversations we've had.
What's your understanding of the point of collecting that information?
To be blunt, it's ticking a box. The law requires you to provide a particular piece of information. Tick, it's been provided. There's no consideration of what the answer is. There's no consideration of if the answer would lead to a higher risk weighting for that particular product or that particular licensee or that particular scheme. If all you're doing is ticking boxes and not looking at the answers, then this is the outcome that occurs.
And ASIC said in its submission that consistent with the economic philosophy underlying the FSR regime, we don't take action based on commercially flawed business models. A significant feature of a number of collapses leading to investor losses is flawed business models. That is, models that would only prosper if asset prices continue to rise and debt markets remained open and liquid. Responsibility for flawed business models lies with the management and the board. What do you make of that statement?
So firstly, for us, it demonstrates the benefit of a relationship with a professional financial planner in helping clients
Yeah.
understand the risks of these type of products. But in terms of the regulator and the way they're regulating, similar to my colleagues from CPA's statement, consumers expect when a product is regulated by the regulator that there is some form of check or some form of quality
Yeah.
assessment that it's fit for purpose for a consumer to invest in. If that's not the case, which is becoming apparent, then I think the disclosures in PDSs and the disclosures in target market determinations and disclosures more broadly around financial products need to be significantly boosted to make it very, very clear that despite the fact that this is a product from a licensed organisation, despite the fact that the scheme has been registered with ASIC, nobody's actually checked to see whether or not it's fit for purpose for a consumer.
Yeah, that's a good way of looking at it, because essentially the PDS in this case should have been essentially amended to say, well, they've been marketed as having a 15% return. In order for ASIC to say that the PDS is adequate, it needed to say we can't guarantee this level of return, and yet it didn't. You still have to assess the business model underlying it, surely, in order to have an accurate product disclosure statement.
Yeah, I mean, I've got a lot of sympathy for ASIC in terms of that. I mean, there are hundreds of thousands of products on the Australian market, and having to, if ASIC's job was to consider whether or not the underlying business case for each of them was appropriate, that's a virtually impossible task. But again, there are certain types of products that tend to lead to these kind of losses. It's not the balance fund at a superannuation fund. It's not, an indexed share fund. It is a highly leveraged property investment scheme that is sold through advertising and seminars. And I would have thought those risks would have been appreciated by ASIC, and maybe they have closer looks at those types of products.
Thank you, Chair.
Thank you, Senator Pratt. So, Senator Pratt, you've got no further questions for these witnesses?
I could keep. They're excellent witnesses. I could keep asking questions, but I thought I should give you an opportunity. I'm happy to keep going.
Okay. Well, I will ask some questions. If I could just ask the witnesses first, did you hear I think you did hear the testimony from the CPA and the questions I asked the CPA in that regard. So I'll start with this issue of professional indemnity insurance, and that is, I think the term was used, how important it is to ensure that relevant players in this space have adequate professional indemnity insurance. But that is dependent upon the market for professional indemnity insurance, isn't it? So there's only so much the government can do to ensure that there is professional indemnity insurance. And then you've got a complicated question about, well, what's a reasonable level of deductible, for example, in relation to professional indemnity insurance. So I'm interested in your comments with respect to the commercial realities of trying to access professional indemnity insurance when ultimately the providers of that insurance have got their own business model, which they're considering in terms of the economics of providing the insurance.
Yeah, absolutely, and you're absolutely right that it's a commercial product, and insurers will decide whether or not they insure risk in Australia, and what type of risks and products they bring to market. Part of our concern, though, is number one, ASIC. The last time ASIC did a review of professional indemnity insurance in financial planning, for example, it was it was 4 or 5 years ago, and the statement, and at the time our members were telling us they were starting to have a lot of problems getting insurance, but ASIC's report says there was nothing to see here. There was no problems with the professional indemnity insurance market. All licensees that were being that were attesting that they were able to obtain a professional indemnity insurance, but there was no consideration of whether or not any of that professional indemnity insurance was fit for purpose and adequate for the risks of those businesses. Since then, the market has significantly deteriorated. Our members are telling us that there's only 2 PI insurers currently in the financial advice sector. One of those is a closed book, so if you've got cover with them, you can't change it, you can't move it, you can't add to it. It is what it is. The other one has got a very small book, and it is, at the moment, it is extremely difficult to get cover. That suggests that there is a regulatory concern about whether or not there is actually a healthy and viable PI market in the country. Now, anecdotally, in conversation I had with ASIC, they tell us they know that there's a problem with PI, but we're not seeing any action in terms of that, which is again why the FPA has been calling for a review of PI and the framework around PI. We've also approached the Insurance Council to try and get their assistance in particularly in the financial advice market. As I said, I can't speak for products, but if we're having so much trouble in financial advice, I can only assume that there are problems in products as well.
Right, okay. You would have heard the question we asked the CPA to take on notice with respect to the response that ASIC gave to a question I put on notice, which was to provide details with respect to the inadequacies that were identified in the Sterling PDS prior to the issue of the interim stop order. And that answer to the question on notice has been provided. And I note that the statement of concerns which ASIC issued was, and I'm just counting the pages, is about 15 pages long. So that immediately raises a concern in my mind with respect to the regulation in this space. And as you rightly observed, we need to be fair with ASIC in this respect. They have a regulatory regime to administer as the regulator, and that needs to be taken into account. But one of the issues which arises in my mind is in circumstances where the regulator is compelled, after going through a process, to issue 15 pages of concerns with respect to a PDS dealing with everything from risk to conflicts of interest to inadequacy in terms of providing the background of the directors of management, etc., etc. That, in my mind, raises the issue as to whether or not the promoters, the responsible entity, should have been permitted by the system, if you like, to amend the PDS and then continue with the scheme, as opposed to the scheme coming to an end because the disclosure was just so materially inadequate that this took this case into the realms of something that just needed to be stopped, as opposed to disclosure corrected in certain aspects to ensure that there was more fulsome disclosure. I'm interested in your views with respect to that concept, but feel free to also take the question on notice and provide observations after you've had the opportunity to read the statement of concerns.
Thank you,
Do you have
Senator.
any preliminary views on that yet?
Yeah, so broadly, this is why we were calling for decades for the product intervention powers and the direction powers that ASIC have now been given to intervene into these types of products when they identify that there are a significant risk to consumers and shut them down. as quickly as possible.
But that sorry to interrupt, we're coming up against a hard deadline, but I just want to tease that out because ASIC has provided us a review of the product intervention power, and they have to come to certain views with respect to the product prior to intervening. But it seems to me that in terms of intervention, in terms of what may happen in terms of product intervention, a key consideration or a key trigger for intervention may well be not just, and I'll quote, where a product has resulted in or will or is likely to result in significant consumer detriment, but perhaps also where the disclosure in relation to the product has been materially inadequate and is unable to be remedied without causing substantial prejudice to everyone who previously had invested in the product before the disclosure was modified. Do you have any views with respect to that?
We'd absolutely agree with that, and I think in the process of the consultations around the product intervention powers and direction powers, we thought they could have been strengthened further in our submissions. I'd make the point, and I appreciate the time restriction here. Recently, we've had the design and distribution obligations commence and target market determination framework start. Frankly, the quality of virtually all of the target market determinations in defining who the target market for the products are, providing relevant information to consumers so they can understand whether or not they fit in those target markets or don't fit in those target markets, are absolutely woeful.
And at that point, Senator, the readability for, particularly in these cases, for consumers who are not receiving advice, I mean, and as an average, a reasonable person who doesn't have a background in financial services to determine whether you're actually in the target market for this, for a particular product is almost impossible. And if these documents were drafted in order for consumers to be more aware of the products that they're actually investing in without actually having to obtain personal advice, I think they have not hit the mark on that at any point. So that's something I think that also needs to be further looked into, particularly by the regulator, to ensure that they're actually fit for purpose.
Because I look at this statement of concerns and I am very interested in your view on it, but I've been involved in the preparation of prospectuses, offering documents in the capital market space as a company secretary of an ASX listed public company, and it is just woeful. And to me, it just raises the question whether or not the people involved in this scheme should ever be involved in another scheme ever again, on the basis of how woeful the PDS was. And sorry, go on.
I was just going to say, I mean, we can't speak for the actions of the regulator or how they investigated this issue, but we started to have a look at the company structures and who were involved. And we spent a couple of days trying to figure it all out, and the web of this in trying to prepare our response, and we just had to give up on it because it was so complicated.
Yeah.
That has to be a red flag
to the regulator.
In terms of saying this is not a fit product for consumers.
Okay, well we'll have to leave it there. I've come up against my our hard deadline, Senator Pratt. So thank you for your evidence. The date for answers to questions on notice is 24 November. So if you could have a look at that statement of concerns, very interested in any observations you have. And the hearing is now suspended until 1:45 p.m. Thank you very much.
Thank you, Senators.
Thank you, Senators.